and you're on you, the practitioner or lawyer.
Thank you.
Thank you, Mr. Chairman.
Appreciate it. Any comments from the? Okay.
Thank you, Mr. Chairman. Mr. Chairman,
Yeah.
may I be excused?
Thank you. Please do so.
Judiciary calls.
I understand that you're taking up some of the bills that we sent over to you. Good luck
we
with.
are indeed.
They're in perfect. They're in perfect condition when we sent them to you.
Thank you.
Do I have a motion? Okay. Any conversation, discussion? All in favor, please signify by saying aye. Any opposed? Bill passes. Do pass. Do we know the macro thing? Okay. Yeah, tell him I need him. Okay, let me see what we got here. We're gonna, if I can find my agenda here. We're gonna next take up SB 573. Which was a bill that we laid on the table for the purpose of bringing back today. I think the first thing that would be in order would be a motion to take it off the table. All in favor? Any opposed? That's what I'm making the phone call right now for. Let me see if you would. We're going to go to German just for a moment. Wait. Now, put him
Yes, sir.
Good morning. We're going to take up your bills. I like to always take the Senate just as soon as we get them in here. Okay. And I think we'll take your first bill will be Senate Bill 530 dealing with the property liens.
Yes, sir.
Good morning, sir.
Good morning, Mr. Chairman. How are you today?
Fine. Hope you are.
Appreciate the opportunity. May I begin?
Yes, sir. Please do.
Senate Bill 530 is a bill that is intended to extend lien rights primarily to utility contractors. Currently, under Georgia law, if you're a foundation contractor and you're hired by an owner to build a foundation for a construction project, if you're not paid, you have the ability to lien that property that you're doing work on. And that's been in Georgia law for some time. If, however, you're a utility contractor and you're hired by the owner to perform a certain scope of work that involves putting in, let's say, a fiber optic cable to that new building, and the fiber optic cable will cross not only the property that the owner owns, but also adjacent public right-of-way or perhaps a private easement in an adjoining private piece of property. If you, as that utility contractor, you put in that cable and you're not paid, you do not have the right to lien the owner's property for the work that you did on the adjoining piece of property. What this change in this law says is that utility contractor will have the right to lien the owner's property for the work he does in a public right-of-way or a private easement. And it's based on it's a result of a Georgia Supreme Court case that came out a year or two ago that ruled in a fairly technical sort of way, construing the statute very narrowly because it is in derogation of common law. And that's really what Senate Bill 530 is.
Being in derogation of common law, we have to, by statute, explicitly state what under what circumstances liens can be filed addressing property claims.
That's precisely correct. Yes.
Do you have any other questions? Senator Weber presented the bill. Yes, sir.
I'm trying to understand the situation. I own a house and I live cable there.
Yes.
Whatnot.
Mhm.
And the cable company runs a line down along the road to my house. With the agreement that I'm going to pay for the work that they're doing.
Yes.
Then I decide not to pay. They want to file a lien against my house, my property for that. The law says now they can only file a lien against my property for the actual work that was done on my property. The lien against my property for the amount of the work that was done on my property, not for the 5 miles it took to get there.
That's exactly.
And you're going to change this so that they can have a lien for the 5 miles worth of work it took to get there.
That's correct.
Okay.
Yes.
And of course, I guess, is it in the situation is I ask for you to do that work,
Yes.
and then I try to back out of it after I get the work done.
That's right. The statute requires that the work be part of the scope of work under the contract between you and the contractor.
Mm-hmm. Okay.
Any other questions? All right, thank you. Yes,
No, no, not that. Just the in this case, Representative Fleming's house that he's having built could be named.
So if you went through my property, I don't own my property, because he owns that.
That's correct.
It's mostly dealing, as I understand, with right-of-way work where you have going to the source, so say like a sewer line is on the right-of-way, you've got to bring the line in to the property that will be benefited from that work. All right, thank you, Senator Weber.
Okay.
Anyone else here to speak in support of or in opposition to Senate Bill 530?
Good morning, Mr. Chairman, members of the committee. I'm Barbara Lynn Howell here on behalf of the Construction Suppliers Association. Just urging the favorable consideration for SB 530.
Thank you, ma'am. Anyone else? Yes, sir.
Montreal Associated General Contractors who support this also.
Thank you, John. Anyone else wish to speak? With the committee, any discussion among the committee regarding Senate Bill 530?
At the appropriate time, Mr. Chairman.
No discussion? Comments? I'll entertain a motion.
Move to pass.
It's been moved to pass on Senate Bill 530. Any discussion on the motion? Any amendments to the bill? Ready to vote on the motion. The motion is due pass. All in favor signify by saying aye. Aye. Opposed, like sign. We have favorable passage on this. Senator, we're going to take your other bill up while you're with us, so we can let you get on the business. That's on Senate Bill 569, dealing with local government.
Yes, sir.
Would you please present to us the Senate Bill 569 in this
I'll be happy to do that. I want to make sure everybody's looking at the committee substitute, LC 18559OS.
correct. One in your folder.
Should be in the folder. This bill amends the statutes in Title 36 that deal with procedures and so on, dealing with formation of a new municipality. As you all are well aware, we have a new municipality in the form of Sandy Springs. We also have four others in Fulton County, County North and South. And we have a situation that's developing between Sandy Springs and Fulton County with regard to certain county properties and the right of Sandy Springs to acquire those properties from Fulton County. Specifically, probably the hottest issue is the parks. Sandy Springs is a well-developed area that has a lot of commercial property. There are only a limited number of parks, and the disagreement between Sandy Springs and the county right now is that Sandy Springs would like to take over those parks, and under the doctrine of home rule, Sandy Springs, as a city, can operate the parks, and the county cannot without the city's approval. So it appears that the county is demanding that there be full market value paid to Sandy Springs for the parks. I'm sorry? To the county. Did I misstate that? Okay. The county is asking, and Sandy Springs has said that they think they deserve a tax credit. I shouldn't say tax, a credit against the purchase price for taxes paid over the last 30 years or so for those parks, as part of the special service district taxes. And that outlines the problem here. The objective of this bill is to first, when a new municipality is formed, to make sure that the residents in that area, the unincorporated area, deserve and receive a tax credit or a credit for taxes paid over the years in the transfer of county properties such as parks, police stations, and fire stations to the new municipality. The second is to assure that the municipality will succeed and have the facilities that they need to operate as a city. And the third is to bring some certainty to the process, because it appears that Sandy Springs and Fulton County may be headed for litigation. So the main thrust of this bill is to set up a procedure where the new municipality, and this would apply to Johns Creek and Milton also, as well as the two cities in South Fulton, first would have the opportunity to negotiate an agreed price. Failing that, they would go to mediation, mandatory mediation before a local superior court judge. And failing that, then the Superior Court judge would conduct an evidentiary hearing to determine what the purchase price should be for those types of properties: police stations, fire stations, and parks. That procedure may sound familiar because it is the same procedure, or very similar to what currently is in law for the Service Delivery Strategies Act, where cities and counties are required to negotiate and determine the best delivery strategy for services. So we lifted some of those provisions out of that statute and brought it over to this statute to implement that strategy. To bring certainty to the process, what this statute does is it sets forth a formula that the court could use absent any agreement through mediation or through negotiation. The judge will be empowered to use a formula that first looks at what's called a tax ratio. The tax ratio is calculated by taking the tax digest for the city divided by the tax digest for the county. And that it gives you a rough cut. Say that's 10%. So the city of Sandy Springs or the city of Milton might have 10% of the tax digest. There is built into this formula a presumption then that municipality, those unincorporated residents for the last 30 years during the existence of the special district have paid about 10% of the taxes. The second part of the formula looks at what's called an asset ratio. You look at the asset ratio separately for parks, police stations, and fire stations. You calculate a separate ratio, but the ratio is calculated again using what's the original cost paid by the county for the parks in the municipality divided by the county's cost for all parks in the county. And if that ratio, the asset ratio is say 8%, that's less than the tax ratio. And the presumption is then that those residents in that unincorporated area have paid for that park once through their taxes. The advantage to this approach is, albeit somewhat of a rough formula, it nevertheless adds a great deal of certainty and can be applied by the judge in a mechanistic sort of way and bring resolution to it and give the city the ability to operate. The same type of formula would be applied both to police stations and fire stations, with one notable exception. In the case of a police station or fire station that might be located in the new municipality, you have to look at the service area for that police station or fire station. If the police station is located in the new municipality but serves an area outside the new municipality, let's say that 60% of the service area is outside the new municipality, the new municipality could purchase the police station by paying 60% of the full fair market value to the county. The logic there being that the county will have to replace that facility to serve that 60% area outside the municipality. I know I'm throwing a lot of facts and figures around, but that's basically how the formula works. And now I believe in this committee substitute we may have for parks changed, and Mr. Chairman, maybe you can help me with, change the asset formula for parks to determine the asset ratio from looking at county cost to looking at acreage. Is that? Yeah, we did change that. So to determine the asset ratio for parks, you would look at the number of acres of park in the municipality divided by the total number of acres in the county. And that's, again, a rough cut. But we need to make sure that our counties and cities stay out of litigation and that cities have their facilities. So this is, again, a formula that brings certainty to it. There are two other parts of this Senate bill that I need to tell you about. First, one part of it would allow a new municipality to remain in a special fire district in a county that has a separate special fire district, and there are a number of counties. Fire services, fire and rescue, are the types of services that are provided more beneficially, more efficiently on a larger scale, and many cities opt to stay within the county. And this just clarifies that they can do that, stay within that special district. The third part of the bill, which is Section 2, has to do with bond proceeds for bonds that have issued for municipal services in a county. If a new municipality forms, they will continue to be obligated, the taxpayers in that municipality will continue to be obligated to pay ad valorem taxes to pay off any bonds that have issued for providing police services, fire services, parks, and so on. We had a bond issue last November in DeKalb County. For the next 25 years, residents of DeKalb will have to pay that ad valorem tax to pay off that bonded indebtedness. In our case, many of you know that I've been promoting the city of Dunwoody. There are funds from the bond proceeds that were earmarked for the unincorporated area of Dunwoody, advertised at the time that the bond was voted on. And so what this provision says is, if the taxpayers have to continue to pay for 25 years, they should get the benefit of the bond proceeds that were earmarked for their area. And it requires the county to spend those earmarked funds in that area, even after incorporation. And that, of course, would apply to other areas. So,
Did not the bond funds program specify what is to be program projects applied
Yes.
to the bond monies?
yes, it is a requirement of law that when the county puts forth a bond referendum, they have to publish which projects and what dollar amounts will be funded from the bond proceeds. And what this law says is those earmarked funds would have to be spent in that area that was formerly unincorporated.
Any questions?
Does that law that specifies the county shall do that, does that apply to any other bonding authority? I don't know the answer to that.
I believe it applies just to the
Fulton County is getting ready to do a public safety facilities authority, I'm told, and
Yes.
For $50 million. Are they required in that?
I
Under the law, you
believe
just go to specify their project. And does this bill have anything to do with that new authority that you're?
it wasn't my specific intent. I would ask you to look at the bottom of page 5. There may be some language there that may give us some guidance. Subsection D1 there, which is existing law. This is the definition of a statement of intention, where it in the context here, it speaks of a county, municipality, or other political subdivision.
So I assume that would be some creation of some entity, bond authority.
The one you're
It could.
talking about is under that, I call it the Public Defense or Homeland Security Authority. The county could set up a $50 million authority. The district would be the county boundaries. The purpose
Yes.
of it would be for their specified need, in this case is the jail situation, which was still
What
included.
I would,
It would affect your, obviously would affect your Sandy Springs as well.
yes, the language that we've added on page 6, if you look at that, I believe that that's limited to just dealing with counties and municipalities. So I don't think it would affect the authority that you're speaking of. That's my initial reaction to that.
I may have one other question.
Yes, ma'am, please.
I couldn't find, look at quickly, where this formula you suggest that you're going to give to the Superior Court judge. Where exactly is that? Is that, must the judge accept that formula, or is that simply a discretionary formula? Discretionary formula.
The formula is set out in page 4. At the top of page 4, line 3 is paragraph 3 there. This is the third step. If you fail negotiation, if you fail mandatory mediation, if no, the judge shall determine. And
So it's a mandatory formula for the judge.
that's correct.
If you like your formula or didn't like your numbers, he or she will be.
Well, I think the factual hearing will determine issues that may be unresolved between the county, the city, as to what, quote, may be the purchase price, what may be the division, the digest, other questions regarding acreage, say, of the parks in the county versus the city.
Yeah.
So there's a dispute about that, then the judge will have need to hold a hearing to resolve those issues by conducting a factual hearing.
I agree with all that. That makes sense to me.
Yes.
What I'm trying to decide, or thinking to ask myself, is whether or not we should tell the judge if there's only one way he or she may determine these numbers together. And that's what I.
We looked at various approaches. I had a number of, over the last 2 or 3 months, a number of different approaches drafted with the assistance of legislative counsel. If you were to say, as we did early, that a new municipality should be given a credit for taxes paid over the last 30 years, so long as the special district's been in effect, that I think is an invitation to protracted litigation. And I think that could be very cumbersome for a court to try to determine. And these new municipalities need to have some certainty going forward as to what facilities they will or will not have available, and what the purchase price within a certain range of certainty, what that might be. And as the chairman pointed out, there will be some fact questions that need to be answered if it gets to this stage by the judge. He'll have to look at the appraised value of the tax digest. He'll have to look at the acreage, have to look at the original cost, and make some factual determinations. If there are other disputes that arise out of this statute, then the judge also obviously would address those. But the formula is intended to give some fairly mechanistic guidance to the judge so he or she can look at it and have some certainty as to how to proceed.
Thank you. Any other questions? Over here.
I believe Representative Bruce was first, Mr. Chairman, then
I would say I have an interest in this. What's happening in South Florida County. Parks and other things, the purchase, someone purchased early on.
Yes.
And I was trying to make sure the value obviously is different than it was at the time of purchase.
Yes.
Does your formula account for that?
3% per annum on the land and any improvements to the land.
And the second question, obviously because everybody in the county helped pay for those properties.
Yes.
And I'm more talking parks than anything else right now. And the parks were available for use by anybody in the county. Is there any intent for a surcharge or some sort of non-residents of the municipality to people that live in the county may have been using those parks at some point in time? Is there any intent of trying to surcharge them who don't live in the municipality?
That's an excellent question, Representative Bruce. I know that the chairman and I spoke yesterday about adding a provision that would prohibit any sort of a surcharge being charged by the municipality.
Fine. Look at page 5, President Bruce, at line 23, that is language is added dealing with that very thing. So that there will not be an increased user fee for someone who's outside the city for those parks. Line 23, section I, on page 5. Next question. Ms. Lindsay.
just want to, for clarification purposes, when it comes to a park, let's start with the park. Are parks paid for by the county out of the special district funds or out of the general fund?
I think it could be either.
Yeah.
Historically, and recognizing that as a possibility, I think that this somewhat mechanistic formula nevertheless recognizes that by looking broadly at the tax digest.
Mm-hmm.
So that if it were paid out of general revenues or special district revenues, nevertheless, you're looking at the city digest divided by the county digest. So the city may have paid for 10% of the general revenues over the years, presumptively, or special district taxes. Does it make sense to you?
A little bit. Because obviously my biggest concern is that, funds paid out of the general fund, that gets taken from everybody countywide, and parks aren't necessarily evenly distributed throughout the county. And sometimes you've got one area who, in the past, out of the general fund, paid for a park in a newly incorporated area. For instance, I live inside the city of Atlanta, and we pay money into the general fund. I just want to make sure that my folks aren't paying for the parks in a newly incorporated city.
I guess we could do on the form that was paid for Chastain as a way of doing it.
Yeah. I don't know. I'm trying to think it through.
Chastain was given to the city, by the way, by Fulton County.
Well, we appreciated that about 40 years ago.
I think one of the challenges is that there's going to be so many different variations, points that could be made, that we tried to arrive at a formula that, again, would add some certainty and resolution.
Okay.
Representative Stevens.
Thank you, Mr. Chair. I have a couple of questions. First, thank you, Senator Weber, Section 2.
Yes.
I like, of course, because this applies to all counties, and I'm from Tab, as you well know.
Yes.
This is near and dear to me. On page 3, I'm sorry, under lines 8 through 18, you talk about paying into an estimated purchase price into escrow. How is that determined absent the formula?
Well, I'll say to you that, in all honesty, this committee substitute was drafted with a few changes. Representative Willard,
we were looking at the concern that I had in my mind from a constitutional standpoint. There's going to be a requirement that the county make the transfer of the property without a resolution of what may be the purchase price if they've gone through the negotiations and it's still in dispute. So what we're doing here is saying, city, you will be paying into what is the anticipated amount based upon that formula as seen, much as we do with what we call a quick take in condemnation. So there is a payment made into the registry of the court, and the county then to have the ability to draw it down without jeopardizing its position. But it would still continue on with the battle regarding what the concerns may be about the formula, what should be applied to it, and how it's to be ultimately decided for purchase price.
Now, the final determination of the purchase price means to me that is once it reaches that portion with the judge. So you're saying that throughout the mediation period, you do not have to have a final determination?
This will only occur when there's a transfer of the property, which I believe in this situation is after the initial negotiations, as I recall, between the county and the city, and that has failed. Then there's going to be an action in court in which the city will make the payment, and that starts the mediation process.
Now, I'm trying to understand the mechanism, how it works as a practical matter, because it has deadlines on within 30 days. Certain things have to happen. How much time are the parties given to negotiate prior to any filing in the court? Is there any time?
Let me ask something right quick. Where's Josh? Would you ask the people outside the door to please move away from the door? That the talking is disturbing the conduct of the committee. Sorry, go ahead. What was your question again, Ms. Stevenson?
The question is there any time deadline, sort of a time to exhaust, if you will, the administrative remedies prior to seeking judicial relief?
Let me go through what I think the timetable is. You have the city make the notice to the county, give the notice to the county they wish to acquire the properties.
Yes.
That notice then triggers a 60-day negotiation time between the city and the county.
Okay.
Yes.
That's what I was looking for.
Yeah,
where's that 60 day? I see on page 2, starting line 22 to the 30 day. Where is the 60 day period? Is that on page 3, starting at the line? No, I see the mediation.
That's mediation.
If you go to page 2, line 12 through 21, this is describes the process where a municipal corporation would adopt a resolution stating their intent to purchase certain properties. And then in the last sentence on lines 19 through 21 contemplates that notice of that resolution has to be given at least 3 months prior to the date that the municipality is removed from the district, the special district. So that starts the process whereby the parties have the opportunity then to negotiate an agreed price. Now, conceivably, either party could demand mediation prior to the expiration of that 3 months, but that's not the intent here. We could make it express that they could not. But failing negotiation, I think then they go to mediation.
Yeah, I think also look on page 2, line 31, dealing with it says such notice shall be provided with respect to each such property no less than 2 months prior to the date the qualified municipality intends to assume responsibility for providing those services using the property. So I think that was where I was using the 60 days as time that will be open before you have the action being filed in court. It doesn't say negotiation, but yes, that's what the intent of it is, to resolve those issues during that 2 month time.
And then, Mr. Chairman, ask one more question.
Sure, please do.
Relating to the bad faith on the mediation,
Yes.
as well as court costs, that's on page 5. Lines 19 through 20. Are there any criteria, because my understanding is the mediation is borne by both parties. And then after that, the judge will make a decision based on a formula that you've already set forth. So I really don't know how that part would be in bad faith, but what would be bad faith in terms of the mediation?
Well, that obviously is something that the judge would decide. That provision that you're referencing on page 5 is the same as what you would find in the Service Delivery Strategies Act, allowing the judge to find bad faith. In thinking whether we should include that here in Senate Bill 569, I determined that perhaps it would be good to have it in there just so the parties would realize that if they don't act in good faith through the mediation process, there could be a consequence down the road. So I think that sends a bit of a message to the parties that they need to try to mediate in good faith. And that's why I left it in there.
Okay. Mr. Chairman,
yes, ma'am.
Is it the way this bill would act that at the end of the day, if mediation doesn't work and it has to be enforced by a visiting or senior judge, it will be enforced pursuant to this formula?
Correct.
Okay. Thank you.
The factual issues may go in to determine the amounts to be used under the formula, but the formula would be the court's direction.
And the factual issues are a function of the mathematical
Correct.
assessment, and the mathematical assessment are the factual portions.
Yes.
Well stated. Representative O'Neill.
Two quick questions, maybe not so quick, and I might be ahead of them on page 6. I'm looking at line 16, paragraph B there. I'm trying to be a good detective and follow the money. Maybe you could paint me a real-life example of what we're trying to say there. Let's assume that this new municipality wants to buy a fire station.
Yes.
It was built by a bond process, or is in some process of that. How does this language relate to that?
If I may, I can give you an actual real-life example.
Okay.
As you know, in the proposed city of Dunwoody, we have a park that's called Brook Run. It used to be a mental retardation facility owned by the state.
Who's we?
The county of DeKalb owns Brook Run, purchased from the state for about $3.7 million 8 years ago. The park has not had a lot of capital investment. As part of the bond referendum last November in DeKalb for parks, about $100 million in proceeds and bond proceeds. $11 million was earmarked for Brook Run for capital improvements to start working on the master plan for that park. Those bond proceeds are earmarked for that park. And if Dunwoody were to incorporate under this provision, that $11 million would continue to be earmarked for that park. And if Dunwoody were to purchase that park from the county, then the county would be required to pay the $11 million to the city, and the city would be required to use that money for that purpose.
Well, I guess maybe that's where I'm having confusion. You got a park that's worth $3 million, that's got $11 million coming to it. That's 14 in some people's mind. And how is that going to work into the formula of value for determining what the city of Dunwoody is going to need to pay DeKalb County for that park? If it knows that it's going to be approved by $11 million in bonds, how does this work? Tell me how that money will work.
Section 2 of this Senate Bill 569 has no direct relationship with the formula that we've been talking about in Section 1. Section 1, which deals with the transfer of the parks, looks historically at what was paid for the park and what the tax digest is of the proposed city versus the county in that formula. So the short answer is to say the $11 million in bond proceeds to be spent in the future is not taken into account in the purchase of the park.
Let me just say, Section 2 deals with an outstanding bond issue that may be, let's say, specifically addressing the circumstances of DeKalb County if there becomes an incorporation of the Dunwoody area. But it doesn't, to our knowledge, apply, except it is general law. If there were a municipality where there's an outstanding unspent bond fund, there would be this language to help guide the county and that new municipality what's to be done with those bond funds, programs directed within the boundaries of that new city.
I've got one other question before we move on, but with all due respect, I would suggest to you that since this is a general bill, and I know it's aimed at Dunwoody, we've got about 17 new cities coming to Fulton County. I mean, I'm being a little facetious, but there's 3 or 4 that this is inevitably going to apply to. And the accounting for all this, I think, is going to be huge, so we don't get cities and counties in civil wars. I mean, this doesn't impose an obligation to take title to these amenities either. It's just the option.
It's the option. That's correct. And this bill was drafted in cooperation with state representatives and senators from primarily Fulton County, because it will affect all those new cities in Fulton County.
Last question, just in a general sense, on the last page, page 7.
Yes.
On line 6. I've never seen anything decided by a 1/3 vote. Could you tell me the logic of 1/3?
I will say to you that language should have been taken out. That was language suggested by Legislative Council some 2 months ago, and I noticed in the earlier version that it was still in there, contrary to what my intent was, and I see now that it's still in there. So it doesn't make a lot of sense to me either, to be honest with you. So I'd certainly be open to amending Senate Bill 569 to take out some of that language, Mr. Chairman.
Why don't you consider what you want maybe use there in lieu of the 1/3? We have some other questions over here, Ms. Oliver and then Mr. Bruce.
There's clearly going to be some other bonding authorities beyond this DeKalb Parks bond from last March. I mean, we're going to be creating, soon, so that makes me nervous. But just that is a pure policy matter.
Yes.
Conceptually, having a procedure and having a judge determine value, and having a timetable so there isn't open-ended, unresolved negotiation makes a lot of sense to me. But I can't, as a policy decision, convince myself yet that giving the judge one formula is a good policy, as opposed to giving the judge, you may use this formula, if you use another formula, it has to be commensurate with some value. That's where I'm stuck a little bit, because I don't, so justify for me, given the judge as a policy matter, one formula to use as opposed to this formula or this.
One approach that you could use, and an attempt was made to do this, was to say to the judge, here's a list of factors for you to consider in determining the purchase price to be paid by the city to the county. Some of the factors you might list is, what is the fair market value of the park? Was the park, what was the original cost of the park? What sort of improvements are on the park? How much has been paid in taxes over the years, in special district taxes, by the taxpayers in the unincorporated area? How much was paid in general revenue taxes over the years? And how much of the money how much did the county draw from both general revenues and special district to pay for those parks or the police stations? And then you need to look at how long has the county owned the park. Have they owned it for 100 years or for 2 years? And if you do that, I think, and you say to the judge, determine a purchase price, I don't think it really gives the judge enough guidance as to what he's supposed to determine.
But let me make another argument. Let's assume that doesn't give him or her enough guidance. Doesn't give them a specific formula take away the advantage of mediation and folks reaching a arm's length negotiation? What you really want is for them to reach an agreement. If you give the judge a specific formula, doesn't that take away their incentives to reach an agreement for the time?
I would respectfully submit that it provides incentive for the parties to come together and reach an agreement. The objectives here, again, are to provide certainty to the process and to avoid litigation. And from the city's perspective, if you're trying to form a new city, or even if you're an existing city, you need to know whether that 100 acres in a highly developed commercial area, you're going to have to pay fair market value or something less. Because if you've got to pay $40 million for a green space for a park, fair market value, that a judge might find without guidance, that is cost prohibitive for a new city.
You've got I'm sorry.
I'm sorry.
So you also have a prohibition in Fulton County. I don't know if there's in other counties, but prohibition, the county cannot operate parks inside the city. And so what we're left with is a standoff if we don't have something there of the certainty that Senator Weber is speaking of. How do we finally get this property over, or does the county say, hey, we don't have to sell it to you, we're just going to turn it into a private development and take away the park from the people who over the years have paid for that park and deserve to continue using it, whether it be north or south? Yes, ma'am.
Thank
Ms.
you,
Stevenson.
Chair. Representative Oliver pointed out what my first question, because if there's a quantitative formula at the end of the day, depending on which party is advantaged, I don't even see why you would even go to mediation, because the end result is a quantitative formula. Second, if the intent of the bill was to apply to the cities of Fulton, then is there not a way to limit this to Fulton County?
Well, keep in mind that this Senate Bill 569 at the start applies only to those cities that are formed in counties that have special districts, special tax districts.
I understand that.
And for instance, for police, there are only 12 counties in the state of Georgia that provide police services.
But you said there's only one county that asked you to bring this bill.
Well, this bill was drafted as a result of a joint desire on the part of a number of senators in Fulton County and myself in DeKalb County to try to address this issue. And speaking with the Sandy Springs representatives, they also wanted to have some certainty, because, as the chairman explained, there's a stalemate that's developing between Sandy Springs and Fulton County. Sandy Springs has the power of zoning, and if Fulton were to try to use the parks to sell to a private developer, then they would have to get zoning approval from the city for that.
One more question, Mr. Chair. Who determines the math for the judge?
Who determines the math?
under the formula for the judge? Who brings that information?
Well, I would assume that the parties to the lawsuit would present their calculations, and the judge would make his own determination.
Based on the two different math, they will look at who applies the formula and what facts they put in, determine whose formula is correct.
Yes, the judge will have to make a factual determination as to what is the appraised value of the tax digest, what is the original cost paid by the county, what is the acreage of the parks, a number of issues like that. And there may be disagreement between the county and the city on some of those issues, and it's the judge's obligation then to try to resolve those factual issues.
Thank you.
Yes.
Yes, sir. Mr. Cumlin.
Sir, I like just one what-if question.
Okay.
I'd like to take it back in and just a general bill, but you had a situation, I'd like to be able to say to a fire department, a fire station,
Yes.
if they're right on the line, but for that happening, the municipality or the county one might have to build a brand new one with the servicing area by law or regulation.
Yes.
They'd have to rebuild it, build it at fair market value, but yet selling it on, the formula which would be on historical costs. I have a little equity problem there.
There is a, may I?
Yes, I could.
There is a provision in here to deal with that situation, which I know you walked in a little bit after we got started. In the event that the fire station, to use your example, is located in the new city, but it serves an area outside the city. If that area, the service area is 60% outside the city, then the city has to pay to the county 60% of the fair market value of that facility. The presumption is that the city has paid for 40% of it, but there's also a principle that the county is going to have to replace that facility at fair market value to serve that 60%. Again, it's a formula that brings some certainty to it and tries to bring some equity along the lines that you figured out, I think. So it's a good question.
You got anything further?
Yeah, just
Mr.
a question as whether or not you explored this possibility or not. Simply requiring that if any of these facilities lay within a newly municipalized area, simply requiring that the county lease these to the new city, and for the city to maintain them. But whenever they get abandoned, then the county gets the benefit of the bargain of the sale. But allow the cities to continue them as long as they wish to continue using them for the same purposes they were using before.
Well, that's always an option for the parties to agree to if they wish to negotiate to that point. In the case of a number of new cities that are forming, I think that they would want to take over ownership from the county so they could perhaps do whatever they want with the property instead of having to worry about a reversionary interest going back to the county someday.
And that continue uncertainty down the road.
I understand. I'm just trying to think.
If the county makes a decision, we're going to turn this to a private development, then they offer it. The city's supposed to zone the property, but the city's going to be also restricted by the constitutional requirements of highest and best use as to someone coming in seeking the zoning of it. So that's again part of that uncertainty as the future rolls on, and you got what is really public need property that needs to be continued to that purpose. Any further questions of the presenter, Mr. Bruce?
This has got to be one of the most difficult bills for me because of the tactics of what we're trying to do.
Yes, sir.
The south side. But at the same time, as an applicant, this thing was driving me nuts with the notion of taking the property and forcing the local government to do something that they maybe not want to do with property within the borough. I do have a question about the property that's not paid for, it's not completely paid for yet. This may come up with some finance that I believe that. How is that handled in the event that the piece of property that we're talking about is not yet fully paid for? And who ends up paying for it, I guess? There's an agreement made between the two parties or whatever. to build a building, to buy, the land, whatever it is. And if that is not fully settled, and now this new city comes along and says, okay, we want this property, we want to build, we want whatever. How, or setting a formula. If that formula doesn't rise up to cover the property, yeah, so to speak, what happens?
I think what you're asking.
Go ahead.
I think what you're asking is if the county has purchased a piece of property but still has debt on the property. Well, in that situation, I would think that the amount that the county purchased it for would be considered the original cost, and that would work into the formula.
All right. Think a minute. Let me suspend at this moment. We have also with us, want to recognize today, Mayor Eva Galambos from Sandy Springs, and I know you've got another appointment facing you. Would you care to address the bill? Come forward.
Mayor, how are you?
Good morning. Thank you, Mr. Chairman and members of the committee. Sandy Springs is very interested in this bill because we have faced an untenable situation since we became a city in December. Everything is going along very well, but we have this limbo situation where we're now operating the parks, and we're doing all the maintenance, and we're running a full program for children and adults. And we read in the paper that the county is considering getting an appraisal of current market value for these parks to put them on the market and sell them. So there's just nothing in state law that gave us a process of dealing with this situation. And of course, as we grew into cityhood, we realized that state law was pretty silent on a lot of points that deal with new municipalities. And this is a serious gaping hole of how you handle transfers of properties. The same thing is true now of the fire stations. But the biggest problem has been with the parks. And incidentally, here we are with the county talking about getting appraised values of parks that were acquired by the county as a gift from what was Western Electric, and then the facilities on the park have been built with user fees. So, it seems a little strange to talk about putting that on the market now. So we are very, very interested in this bill, and we think it would put a process in place so that we could deal in a rational manner and move ahead. Thank you.
Any questions of Mayor Galambos? We're glad to have you with us today, Mayor. Thanks for coming in. Anyone else wishes to speak in support of Senate Bill 573? I'm sorry. I got the wrong number. 569. Anyone else wish to speak in favor of it? Anyone? Yes, ma'am.
Susan Pruitt, Georgia Municipal Association, and I'll speak in favor of it simply to put in a process for resolving these, and that's what I would commend to you, is that there be a process so this does not go on indefinitely, and to avoid litigation between cities and counties. That's never good for the taxpayers, ever, to be funding both sides of litigation. So there will be new cities in Fulton coming online, and this is going to be an issue they're going to face as well. So I would encourage you to put in a process that gets the parties to a resolution in a timely fashion, an equitable resolution for everyone.
Thank you. Yes, ma'am.
Do you have an opinion about whether or not the process must include a specific formula for the judge to consider, or should the judge be given greater value?
We don't have a position on that. We simply believe that it is critical for there to be a process that leads to some finality and that is equitable, because the residents of the city are also residents of the county. In this instance, they've been paying special district fees, which have gone to some of these specific amenities. And so we do want to make sure that those citizens are not overburdened as their new cities start to form.
Any further questions of witness? Anyone else wish to speak in support of the Senate Bill 569? Anyone wish to speak in opposition? Ms. Hutchins.
How did you guess, Mr. Chairman? Good morning,
Glad to
Mr.
have you
Chairman
with
and
us.
members of the committee. I'm Diane Hutchins, Executive Director of Intergovernmental Affairs for Fulton County. Since I have not had a chance to read this committee substitute, I cannot speak to the specificities of the bill. I have heard what Senator Weber has outlined, but in general, the Board of Commissioners voted last Wednesday by a vote of 501 to oppose this bill. The rationale was that they did not think it was appropriate for the General Assembly to dictate how county-owned property was disseminated, that should be something that should be dealt with between the city and the county. The only specific point I'd like to get to would be something that Representative Lindsay referenced about the possibility of leasing these items. As I said, I have not seen the committee substitute, but from the version that I have, essentially the municipality dictates how this process goes by making its determination as to whether or not it wishes to purchase. Once it makes that determination and passes a resolution to do so, all bets are off. There would be no possibility to lease. So the Board of Commissioners would ask you to give this a do not pass recommendation, and I thank you.
Any questions of Ms. Hutchins? Let me ask what has the county been in discussion process of getting appraisals of the park properties with the thought in mind of potentially selling those to third parties up in Sandy Springs?
Mr. Chairman, I have absolutely no information about that whatsoever.
Okay.
I'm sorry.
Thank you. Any other?
Question on what you just asked.
Yes, sir.
Is that the thought that these properties would be sold to third parties, even built? Somebody, I was watching TV last night, somebody bought a school and turned it into a house where they live in the school.
That's surplus property.
Yeah, I mean, so is that, I'm trying to figure out what's driving this. You know, I'm hearing, you know, that you were trying to do a city out in Head County, and now all of a sudden this is becoming an issue for Fulton County. I'm just trying to understand what is okay. And I think Chairman over there was kind of leading with following the money to see where people are going. And I'm not sure I see where it's all going to be.
Let me, okay, Mr. Fleming.
I follow this somewhat closely, but I'm no expert on Atlanta and Fulton County problems. But I know Fulton County is a little strapped right now, cash, and looking for some money. And if we don't pass something like this, it would be possible for Fulton County to sell a park and someone put a building up there. And that's, and I know you can't sit here and speak for the Board of Commissioners what they may or may not do. But if you got a multi-million-dollar property up there in any city, whether it be South Fulton or whether it be North Fulton, I mean, unless we put a process in place, what's to stop that from happening?
I think we're talking about discussion among the, is that a question to Ms. Hutchins?
She may have an answer why that's
All right.
not going to happen for that.
I think Representative Fleming, one of the answers has already been given, and that is the fact that particularly in the case of Sandy Springs, and it's anticipated that would also be true for cities of Milton and Johns Creek, and ostensibly for the city of South Fulton and Chattahoochee Hill Country, they have taken over, Sandy Springs specifically, immediately took over, as quickly as the law allowed, its zoning process. There's nothing right now, ostensibly, that would stop the county from selling the property. However, as Mayor Golumbos, I believe, said, and as the chairman said, the zoning issue takes care of that because the city would have to be ready to zone it. So I think at that point there may be an impasse. You might be able to sell it, but the question becomes, for what use could you put it absent the city's agreement? So I think that's the answer to the question.
Mr. O'Neill.
Mr. Chairman, just not really even tongue-in-cheek. If this was private property, there would be powers of eminent domain available to government. Is there no such power available to the cities over the county?
I think that's limited as to the ability for a city to condemn another public entity's property, as long as it has use of it, and then if it declared a non-use of it, then potentially, perhaps it could be a condemnation of it. Then you're still in court battling about values. That's the last issue there. The concern, frankly, is, and I've had comments I read in the paper about desire of some commissioners to seek a sale of these properties, potentially by getting appraised value and then finding a developer that wants to pay those dollars for it, which are properties really acquired either by gift or by purchase with taxpayers' monies. And I sit here as city attorney, sort of in a dual role, frankly, city attorney of city of Sandy Springs, because I know some of the background as far as acquisition is, and what we're talking about in this bill is just putting something in as a mechanism, as a formula to resolve this point so that the use continues as a public use. It is in jeopardy. It is in jeopardy.
Doesn't it constitute a taking on behalf of the city?
It is not a confiscation because there's a value to be paid, and the value has to be paid at the time, the trigger mechanism, the 2 months. Yeah, I know. There's not a taking, there's payment to be made. The bill calls for payment to be made under that formula. The question is the policy of the state through the action of the General Assembly in saying this is something that should be done or in place as a way of resolving a dispute between two governments over transferring of these properties. Because I say in Fulton County there's not even a use. Fulton County cannot even continue operations of parks based upon restrictions in the law. So there has to be a leasing, but again the leasing is there's no certainty how long that can go on. And the law we did last year set up a transition time, and it only compels the county in this case to provide the use of these parks to the city during the period of transition. When that comes to an end, all bets are off. We're back to where we were, and the risk is extreme.
Isn't it compelling them, excuse me, Mr.
Yes, sir.
Isn't it compelling them to sell the property?
This bill would say there will, if there's an option election by the municipality to acquire the property, there will be a transfer of title or sale of the property based upon the formula within the bill establishing how that value will be arrived.
I guess what I'm trying to distinguish, because of the overall policy of not the Fulton County, Fulton County's business is theirs, and I don't want to try to interrupt it. I'm certain it's way bigger than me. But really, aren't we codifying city condemnation in a sense? It's
City
setting a formula
condemnation.
for buying property.
I think what Senator Webb pointed out is between two governments we have similar things dealing with, like the strategic service agreements. We have also the local option sales tax. All these things call for there to be a negotiation between the parties, and if there's not a resolution of that between the parties, there is by statute a fallback provision, many times a formula that will be used to apply a resolution of those issues between the two governments. Between two governments.
For that statute.
Yes, sir. And that's what Senator Weber earlier was saying. We have followed within this bill a lot of the language from the strategic service agreements as to what and how those things happen, to set up this mechanism of negotiation, mediation. Finally, if you can't get it resolved, it has to go to court to get it resolved. That's what we've done. It's part of it. Any further discussion? Thank you, Ms. Hutchins.
Thank you, Mr. Chairman and members of the committee.
It's in the rest of the committee. Discussion among the committee members. Anybody have a committee discussion? Ready to entertain a motion?
There was a change, I think, Mr.
Yes, we'll get a motion one way or the other, then we'll talk about changes. Move to pass.
Second.
Moved and seconded. And do we have any amendments to propose to the bill? Yes, ma'am. Ms. Oliver? Two amendments. All right. State the first and give us the page and line reference.
Page 7, beginning on line 6. After the word unnecessary, put a period and delete the language without a concurrent declaration by 1/3 vote of the governing body of such newly formed municipality. And I'd like to ask a question of the author about that.
Yes, ma'am. Please do.
What is the necessity of amendment deletes the proposed provision.
This, thank you for your question. It's a good question. We're dealing with Section 2 here, which again deals with the relationship between the county and a new municipality and the bonded indebtedness funds from which have been earmarked for that city. So I'll use the Brook Run example again, since I'm most familiar with that. The citizens of the unincorporated area of Dunwoody, if they incorporate, would continue to pay for 25 years on those bonds. So the rationale is that $11 million that's earmarked for Brook Run should be spent there. Under the current law, the county currently has the ability, with a supermajority vote, 2/3, to declare that $11 million project unnecessary. This language on page 7 that you reference is an attempt to prohibit the county from doing that.
Prohibit, even if it may be good policy.
Yes.
Even if it may be good policy to sell a piece of property to a developer with the idea of using the money buying the property, you're saying that they can never.
In the event that that area were to incorporate, then those funds should be spent there, because the relationship between the county and the proposed municipality or the new municipality is oftentimes strained, and it's an attempt to keep the status quo in place and not to allow any actions that would prejudice the taxpayers in the new municipality as a result of incorporating.
Mr. Chairman,
Yes, ma'am.
may I, parliamentary inquiry, may I withdraw my amendment and make another?
The amendment has not been voted on, so you can withdraw it.
Withdraw it, I'd like to make a movement that all paragraph B, lines 3 through 7.
Page 7. The amendment, motion is to, by amendment, delete paragraph B beginning on page, line 3, correct? Any discussion on the amendment?
Mr. Chairman, can I ask you to solve this question?
Yes, sir.
Trying to understand what you're getting, and I think I do. Let me give you an example. You got a new city that's going to this park there. I think you and I both would agree that that needs to probably remain a park unless the city decides, the new government, for whatever reason, they need to use it for something else. And my understanding of this paragraph was to keep the county from selling that before the city had a chance to do what they wanted to with it. I mean, maybe I missed something in the explanation.
Would you like for me to try to explain that?
Yes, sir.
Okay.
Is that the way you understood it, Representative
Okay.
Oliver?
I understood it that in no circumstances could the county make that determination. And I don't think that I want to tell a county that they can never make that determination. I don't think.
How about with the concurrence of the local municipality?
If
Now-
that were true, then I would.
Now, all we got to do is strike out by 1/3 vote on line 6 to do that. It says, shall not do it, declared unnecessary without a concurrent declaration of the governing body of such newly formed municipality.
So I'm going to make a third one.
That's what we're trying to accomplish here.
Thank you.
Okay.
No, I'll make a third amendment. I withdraw my first two. This is my third attempt. On page 7, line 6,
Yes.
I'd like to eliminate by 1/3 vote.
All right.
And so it shall read without a concurrent declaration of the governing body.
Thank you. Any discussion on the motion? Motion to amend. All in favor of Representative Oliver's motion to strike by 1/3 vote on line 6, page 7, signify by saying aye.
Aye.
Opposed, like sign.
Second,
Motion. Second amendment you have. All right. What is that?
page 4, line 7. I'd like the shall read may, and I'd like to add the following language at the end as follows, and shall make specific findings of fact relative to said factors. The judge may determine the purchase price as follows and shall make specific findings of fact relative to said factors.
Okay, the only concern I have is the judge so often says, what am I supposed to do when the state General Assembly can't give me specific directions to how to do it? That's what we're gonna have running into. Because you ask the judge to do something in his wisdom that we're not able as a policy to say for the court, here's how to follow it.
Could I get you to repeat that?
Yes, sir. Repeat the amendment. You want to repeat your amendment?
Delete the word shall on line 7, page 4, and insert may, and then before the semicolon, follows, add the following language, and shall make specific findings of fact relative to said factors. So that the sentence shall read, the judge may determine the purchase price as follows, and shall make specific findings of fact relative to said factors. I'm happy for any improvements upon that. My intent is to give the judge a formula that he or she may use and require he or she to make specific findings.
Yes, sir, Mr. Fleming.
Once again, Ms. Alder, trying to understand your amendment, and I'm sympathetic to your idea that we give them some flexibility in there. That's not my problem. But if you change that shall to may, do you then get the judge the ability to not make any decision on what the value of the property is?
I don't think that you anymore give a decision to not make a decision on the value, and you give the judge a decision to not make a decision as to custody, or not make a decision as to.
Is it possible to go back and say, okay, you city, county, y'all go over that, and you come up with a resolution, or I'm not going to decide for you?
Well, that's what a judge does about me.
Yeah. Like in divorce cases.
And my point is this,
What
do
this
we
is.
want that to happen? Do we want the resolution not to come to a head?
I want the process and the time, and I think that's a very good step. And I want there to be a Superior Court judge who is telling the parties, go out there and sell it. But I am too nervous about this specific formula being too narrow a mechanism for the court.
So your idea would be that we give a judge power to go decide it, but we don't force his hand on how to do it, or on if to do it.
And but what I am saying to the judge, this is the formula we like, and I'm requiring that you make findings relative to these factors. I think that's a compromise I'm offering for the committee's consideration.
If I may, Mr. Chairman.
Any further discussion first on that point? Okay,
Well, yeah,
Mr. Lindsey,
no,
I'm ready, just.
And this is on Representative Oliver's point, because like Representative Fleming, I'm sympathetic to your point of view, but I'm trying to say, trying to step back and go, okay, Judge, if you don't follow what we're saying you can do, what are the parameters for the judge to make a decision? Surely there's got to be some type of factors or parameters that he's got to look at that someday perhaps the Court of Appeals judge will look at to see whether or not he abused his discretion or not. And I'm at a loss to figure out what are his parameters if he doesn't follow this formula. And I understand the flaws in it, but what are the
What if the amendment were drafted this way, just for the purpose of discussion? The judge shall consider the purchase price based on the following specific finding, and shall make specific findings of fact relative to the purchase.
Still leaves it open to
It still gives him
uncertainty.
or her. It's not a mean. My intent, and I'm happy for y'all to improve the mechanism of my intent, is to require the judge to make findings of fact on these factors, and give the judge the requirement that these factors be analyzed and considered, but not impose specific formulas.
if you could, again, shall consider the following.
Factors relevant to determine the purchase price and shall make specific findings of fact relative to said factors is an alternative amendment that I may, as I speak it, would like better.
Give us your wording again from the point the judge.
I'm going to give you a second attempt.
All right.
The judge shall consider the following specific factors to determine the purchase price and shall make specific findings of fact relative to said factors.
Mr. Bundry, you had a question, look on your face.
I couldn't keep up with her in writing.
The judge shall consider the following factors to determine the purchase price.
Let's slow down a little bit.
The judge shall consider
The following
factors to determine the purchase price, comma, and shall make specific findings of fact relative to said factors, which may be superfluous here, he may be required to findings of fact.
Okay, after purchase price, determine the purchase price and what?
The judge shall determine the following factors to determine
No,
the
you,
purchase
let me
price.
stop, you read again.
comma,
You said the judge shall consider the following factors to determine the purchase price and,
and shall make specific findings of fact relative to said factors.
hold on just a minute, please. And shall make specific findings of fact
Relative to said factors. I'm keeping the word shall and I'm replacing the word determine with consider and requiring the judge to make findings of fact.
Can I suggest relative to the following factors? All right, let's stop for a second. I'm going to read back what I have. May I? We're striking after the judge shall. We're striking determine the purchase price as follows. And we're going to insert and read as follows: the judge shall. And then from that point, consider the following factors to determine the purchase price, comma, and shall make specific findings of fact relative to the following factors. Mr. Fleming.
I think that solves what I was worried about and also accomplishes what you want. He's got to find a price now, and he may consider these or use a different form if he thinks it's better.
Yes,
Yes.
Clarification. Representative Oliver, is your language in respect to shall consider, is that tantamount to including but not limited to language, in your opinion? Okay. Thank you.
We have a motion. Further discussion on the motion. We read back the language. Everybody understand the motion? Mr. Bondrick, you have it?
I have it, sir. I believe the comma's out of place, if you don't mind deleting the comma.
All right, so take out the comma after price. So read, the judge shall consider the following factors to determine the purchase price and shall make specific findings of fact relative to the following factors, colon. Any further discussion on the motion? Read again.
I understand what you're saying, but I don't know how that's different than the way it reads now. I don't see the difference because as a practical matter, those shells modify everything else. If you shall make findings related to those factors, then how then do you bring in other factors?
I think that my intent is to not limit the judge to consideration of only those factors, but to give the judge broader authority beyond those factors. Have I not accomplished that?
It may be.
Well, I'll read it one more time, then we'll suspend discussion. The judge shall, at that point, as we are on that line 7, strike out, determine the purchase price as follows. We will insert under the motion, consider the following factors to determine the purchase price and shall make specific findings of fact relative to the following factors, colon.
I read that the judge shall determine the purchase price and he shall consider.